I think that the gloss you put on the procedures language doesn't go all that far. I mean, even if you say it's a challenge to a procedure that extends to all cases, I mean, agencies have a lot of procedures, just as courts do. And, suppose you claimed something about the way agencies treated witnesses, or what kinds of witnesses were allowed, or what kinds of cross-examination, or when subpoenas were issued, or you could just keep on going. I mean, would all of that go to a court first?
I don't think so, Justice Kagan, and that's sort of the beauty of the Thunder Basin factors, because if you're talking about a procedural provision that's put in only by a rule, and you want to challenge that, I think you could say, well, that's actually within the agency's competency to fix. But if Congress passes a new agency tomorrow, and it just says, the citizen's going to be dragged in front of there, and they're going to be denied any ability to call any witnesses, I would think that you would actually want people to be able to get into court immediately and say, well, that's crazy. That we should declare that restriction is unconstitutional. It doesn't turn on the circumstances of any individual's case. So I do think that's the right rule, but and I think our particular due process challenge, I think, is a strong case because it's a step that's anterior to the agency itself's process.
So can I ask, just on the actual challenge that you've brought, it seems to me that the hardest of the Thunder Basin factors for you is the meaningful review factor, because basically what we think about appeals generally is you have to wait till the end, and often that's a lot of inconvenience, it's a lot of expense, but we're very stingy in allowing interlocutory appeals as long as you'll get your chance in the end. So what makes this different?
So what makes this different is that the relief at the end of the process doesn't really go to the heart of the constitutional injury, which is being subject to the unconstitutional agency action. There's sort of a
So I thought you were going to say that, and I was trying to think of other examples that are pretty analogous to it. So I would think that when somebody claims that a court did not have subject matter jurisdiction, or when somebody claims that there was no personal jurisdiction as to that person, or a criminal defendant saying that a prosecutor was unconstitutionally appointed, all of these are basically saying the entire process is illegitimate and I should not have been subject to it. So what makes yours different from those?
Well, two things, Your Honor. I mean, one, as to the removal, provisions and the Humphreys executor claim, for that matter, as to those provisions, there's a big difference, which is all of the cases that are already in federal district court, it's taken as a given that the Article III judges are legitimate, properly appointed, properly insulated by good behavior and all of that. Whereas here on the Article II claims, we're basically saying that the process we're stuck in until we get to Article III court is itself constitutionally deficient as a structural matter. So that does seem kind of fundamentally different. And then with respect to the other claims, I mean, nobody says in the situation of the district court, Court of Appeals, collateral order kind of context, nobody says that the district court is powerless to hear the claim in the first instance. It's just the district court's perfectly powerful to hear the claim. It just ruled against you. And in this situation, if we have a claim before the agency, like our due process claim about the clearance process, that is anterior to the agency has no business deciding it, that doesn't seem analogous to the situation in most of the collateral order cases. And of course, even in the collateral order cases, you do have things like double jeopardy, where you conceptualize the injury as really being subject to the procedure, or the proceeding rather. And I would say that it's a fair description of the claims that we're bringing.